What are rules of engagement for private military companies? Have you ever wondered how private military companies decide when and how to use force? The rules they follow are called rules of engagement. These rules are essential for guiding their actions during operations. They ensure that these companies operate within legal boundaries, especially under international humanitarian law, which includes the Geneva Conventions and the laws of armed conflict. At their core, rules of engagement for private military companies define the conditions under which personnel can use force. They aim to balance mission goals with the need to protect civilians and property. Unlike regular armed forces, these companies work under contracts that outline their activities. Their use of force must align with national laws, agreements with host nations, and international law. One key aspect of the rules of engagement is authorization and coordination. Private military companies must have formal permission to carry weapons and engage in combat. They need to coordinate with military forces to prevent misunderstandings, especially in active combat zones. This includes having clear communication plans to share threat information and ensuring military units can quickly identify private military company personnel. Another important element is the limitations on the use of force. Personnel receive training on handling weapons and strict rules on when to use force. These rules often focus on self-defense and protecting others. Offensive actions are usually restricted unless explicitly authorized. The use of force must comply with the laws of the host nation, status of forces agreements, and principles of international humanitarian law, such as distinguishing between combatants and civilians and using proportional force. Compliance with international humanitarian law is also critical. When operating in conflict zones, private military company staff must respect laws that prohibit targeting civilians and requiring humane treatment of all individuals. If personnel engage directly in hostilities, they may be considered combatants and lose protections typically afforded to civilians. This could lead to criminal responsibility for violations of international humanitarian law. The legal status and accountability of private military companies can be complex. They often operate in a gray area since they are non-state actors. Unlike regular armed forces, they may not be formally integrated into national military structures. However, they are still bound by international law and can be held accountable for breaches, including war crimes. Political and operational considerations also shape the rules of engagement. These rules reflected national policies and diplomatic concerns, often limiting engagement to avoid escalation or negative international reactions. They serve as a control mechanism for transitioning from peacetime to combat and help with mission planning and training. In practice, the rules of engagement for private military companies are detailed in contracts and operational directives. These documents specify where they operate, the threats they face, and their protection responsibilities. Training records on the use of force and weapons qualifications ensure that personnel understand the legal and ethical limits of their actions. Overall, the rules of engagement for private military companies integrate fundamental aspects of international humanitarian law. They ensure that the use of force is lawful, necessary, and proportionate while emphasizing civilian protection and respect for the laws of armed conflict. This framework aims to mitigate risks associated with private actors in warfare and uphold the standards set by the Geneva Conventions and related legal instruments.